The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law, and now the 8th Circuit is set to rule in this case, and the entire case might be thrown out. So let's talk about what is now happening. Now, really quick before we jump into this video, I want to thank everybody that's been subscribing to the channel. Our goal right now is to hit 700,000 subscribers. So if you're not currently subscribed to the channel, please consider subscribing, but also thank you guys so much for all of your support. And I want to thank the sponsor of this video, which is Kershaw Knives. Kershaw makes some of the best knives available on the market if you're looking for a quality EDC knife. I love their knives. I carry their Kershaw Iridium knife every single day for my EDC. And right now, if you go to their website and you order using the code ARMED40, you can get 40% off of your order. So head over to Kershaw Knives, pick yourself up a quality EDC knife. And again, thank you to Kershaw Knives for sponsoring and supporting this 2A content. As I mentioned in the intro, in this video, we're going to be talking about an 8-1 order that was issued by the United States Supreme Court and how it's impacting a state's Second Amendment sanctuary law and the fallout after that order. The recent Supreme Court order denied a stay, which would have protected the state of Missouri's Second Amendment Preservation Act, or their SAPA. After that denial order by the Supreme Court, this case was then sent back down to the 8th Circuit, who recently heard oral arguments in this critical case. The 8th Circuit will now decide whether or not Missouri's SAPA is in fact valid, or whether or not the lower court was correct in completely blocking and shutting down this law. But now the state of Missouri has a new decision in their favor and is using it in support for why this lawsuit should in fact be completely thrown out, why the federal government here had no standing to actually bring this lawsuit and has no ability to actually challenge the SAPA law in Missouri. Now, for some background on this case, back in 2021, Missouri passed this law, which is the Second Amendment Preservation Act, or SAPA. This law here in Missouri essentially prohibits and prevents Missouri's officers, agents, and government officials from helping federal agents or the federal government who is attempting to enforce inconsistent federal laws which violate the Second Amendment. The law also created a civil remedy where anyone, an individual, a private individual, could sue Missouri officials, file civil suits against the state of Missouri and its officers or agents if that officer or agent or the state engages in some kind of conduct that violates the SAPA law. Now, in response to that, the Biden administration and the federal government sued the state of Missouri for passing this law. In this case, the United States government sued Missouri under the theory that the law is unconstitutional because the statute is premised on an incorrect interpretation of the Second Amendment. Essentially, the federal government is arguing that Missouri's super pro 2A law is unconstitutional and the federal government's more limited interpretation of the Second Amendment is correct instead. Now, on review of this issue, the federal court there, the district court, did review this issue and ultimately agreed with the Biden administration and struck down this entire SAPA law and put a block on it so Missouri could not enforce it. The Missouri law is in some ways similar in nature to what Texas did with their abortion law, which was SB 8, which was recently reviewed by the Supreme Court and ruled on in a case called the Whole Women's Health case versus Jackson. Now, SB 8 there in that Texas law essentially shielded Texas and its officials from lawsuits since the statute allows only individuals to bring a lawsuit. The enforcement mechanism of the SB 8 law in Texas was essentially designed in a way to make it harder, if not impossible, to have the entire law struck down, because what is happening there and what is happening with Texas and Missouri and the way that they structure their laws is that the enforcement mechanism there is not in the hands of the governor, it's not in the hands of the attorney general or any of its officers or agents. Instead, the enforcement mechanism is left to private individuals to file private civil lawsuits. So what happens because of that is you can't get an umbrella injunction against the entire state, against the attorney general or the governor. Instead, you would have to get a preliminary injunction or a full permanent injunction against the individual who is filing that private civil suit. But then someone else could pop up, file a new civil suit, and then it could go on and on. So you can see how these are structured in a way to essentially prevent these umbrella injunctions. The Supreme Court found that since the state of Texas and that law is not enforced by the state or its officers or agents, well, then you cannot seek an injunction against that entire law. You also couldn't even get an injunction against the judge who hears one of those lawsuits, or even the clerk who helps to file those lawsuits, because that was one of the wrinkles in that case where the federal government was trying to get around that by saying, okay, we're not going to seek an injunction against the attorney general, the governor, or any of these officers or agents, but then we're going to go after the courts directly themselves and try to get an injunction against the judge from hearing a case or even the clerk from filing it. And what ended up happening there is the Supreme Court said, no, you can't even do that. So that's the backdrop of what Missouri did with their SAPA law and the similar structure that the Supreme Court has already reviewed in that SB 8 case out of Texas. Now, after the district court ruled in favor of the Biden administration here in this case, striking down the entire Missouri SAPA law, the state of Missouri then appealed that up to the 8th Circuit. Missouri also asked for the 8th Circuit to stay that lower court decision while this appeal was taking place. However, on review, the 8th Circuit denied that stay. That then led Missouri to file an emergency application up to the Supreme Court, and they wanted the Supreme Court to grant that stay. They wanted the Supreme Court to step in early and protect their SAPA law, at least until this appeal was resolved. But then we got an order from the Supreme Court, and it was an 8-1 order denying that emergency stay. The Supreme Court denied the emergency protection of that SAPA law, and only Justice Thomas was in favor of actually granting that stay and protecting this law while the appeal was going on. Now, after that Supreme Court denial, this case was then sent back down to the 8th Circuit, who has now heard expedited oral arguments in this case. We are now currently waiting for the 8th Circuit, a 3-judge panel there, to rule in this case. Now, during the arguments in front of that 3-judge panel, the state of Missouri and their representative argued that this entire lawsuit brought by the United States government against them is in fact invalid because the lawsuit does not have a proper named defendant, that they are suing people, again, like the governor, the attorney general, and all of these officers and agents who actually do not enforce this law. Only private individuals have the ability to enforce this law under the language. They also went on to state during their arguments that the United States government cannot identify a single act by the state of Missouri or any of its officers or agents that they actually engaged in that harmed the United States government. So there is no injury to the federal government, and again, therefore this lawsuit is not valid. Now, after those arguments, the state of Missouri then received some support from a different decision that happened in the 8th Circuit from a different panel in a different case, but is relevant for this lawsuit here dealing with SAPA. Missouri submitted a letter to the 8th Circuit on why the federal government does not have standing to sue them based on that recent decision, and that this entire case should in fact be thrown out by the 8th Circuit. In the letter, Missouri states that in the Ark of Iowa versus Reynolds case, the court concluded that plaintiffs failed to establish traceability when they sued the governor and the director of Department of Education over a statute which prohibits mask requirements in schools unless otherwise required by law. Any injury stemmed not from the governor or director, but from the schools who did not impose those mandates. Similarly, here the United States has not shown that defendants have a duty to enforce the Second Amendment Preservation Act or that they have attempted to enforce it. If the United States has an injury, it stems from the threat of enforcement by private individuals. In Ark of Iowa, this court also concluded that a plaintiff could not assert rights that it believed schools had because that dispute was between the state and the school districts, but the United States has done that here. It has in effect asserted not its own rights, but rights that it believes political subdivisions in Missouri also possess. So there they're pointing out the structure of their own Missouri SAPA law and how the new interplay with this 8th Circuit decision essentially says that the federal government cannot trace any injury from the state law here directly to the federal government, and the type of relief that the federal government is asking for actually doesn't cure any injury to the federal government itself, but instead gives protection to state officers and agents who aren't actually the ones who are the plaintiffs in this lawsuit. So essentially the relief that the federal government is getting not for themselves, but for these state officers and agents. Now, of course, the Biden administration does not want their lawsuit thrown out by the 8th Circuit, so they have filed a response to that new authority. They argue in the response that the decision offers no support for Missouri here. As discussed at length in our response brief and at oral argument, this case is not a pre-enforcement suit against inopposite defendants and premised on fears of future injury. It is a suit against the state itself to enjoin further implementation of a statute that purports to nullify federal law and that has already caused numerous concrete harms to the United States. So what the Biden administration is arguing here in the response letter is that they do have, in fact, a sufficient injury in their eyes that is caused to the federal government by this Second Amendment Preservation Act passed in Missouri, and that the injury can be traced directly to the state and this law, and that that injury can be cured by this broad injunction that was issued by the lower court. Here now what's being argued is whether or not the federal government here, the Biden administration, actually has standing on their own to file a lawsuit against the state of Missouri because they passed this Second Amendment law. So again, that new decision by the 8th Circuit is helping here in Missouri. We're going to see how this plays out. So if anything else develops, I will let you guys know. Also, if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.